Welcome everyone to IP Master Classes number 3. I'll be speaking about IP in synthetic biology today. And let me start with acknowledging the traditional owners and custodianship of them on which we gather today. So I'll be speaking about the key features of intellectual property and patents mainly, and I'll explain why. And Brad and Hamish have talked about the key features already, so it'll be a quick recap. And then I'll move to subject matter and patent eligibility requirements because I identified them as important topics for synthetic biology. And with regards to patents, and then it'll be presented as a comparative analysis. Of Europe, USA, and Australia, because usually one files patents in several jurisdictions rather than just one. So intellectual property is a generic term of various legal regimes, which includes patents, plant breeders' rights, trademarks, copyrights, moral rights, and designs. For synthetic biology, the most relevant, I would say, is patents because they're technical teachings, and protection is provided through the technical teaching and the technical specification of the invention. So usually inventors seek patent protection in the jurisdictions they wish to enter as markets as well. And plant breeders' rights, my colleague Hamish beautifully explained yesterday. Plant certification and as a form of intellectual property is available for plants. It's quite speaking for itself. And trademarks, it's not the most technological thing. It's usually it's usually used for a brand identity. It's a sign that consumers or buyers can identify. It's a source identifier so that the consumer would know who's producing what by following the trademark. With regard to biotechnology and synthetic biology, especially in pharma, in order to extend the life cycle of patent protection, sometimes companies trademark the ingredients, the name of the ingredients. So when the patent term is over after 20 years or 25 years, I'll explain later in a minute. Since the trademark protection is perpetual, if you renew the registration in every 10 years, the name of the ingredients, if trademarked, they could sell that specific medication even though the patent is expired. So there's a market share of the company on a specific product. And copyright could be relevant, of course. The gene sequences are represented by letters. You tell me, you know much better than me. So they're considered as literal works, and copyright is mainly dealing with artistic creations. So, but the downside, not the downside, but the feature of it, the threshold of originality is pretty low, and it disallows people to copy your work. So a minor change in the work could escape the protection. So that's why patents are preferred over copyrights as a form of intellectual property protection for technological things. And moral rights are mostly, again, related to artistic creations. It gives the author, the creator of the work, to be named by the author, and it also disallows other people to destroy the work of a painting, for example. And designs, they're mostly mechanical things, and this is not super relevant, but there is a protection available for designs. And intellectual property rights are duration and territory limited. This means except for trademarks, because you can renew them perpetually. Patents are 20 years, the duration is 20 years, and copyright life plus 70 years of the author, and it's all designated with international agreements and national laws. And you register the IP generally. You don't have to register copyright. It's automatically granted after the creation, but you usually register intellectual property rights within the relevant office. So the territory is designated while you're registering it. You choose where to register. It's important because by doing that, you choose where it has the effect. And Hamish yesterday talked about the theoretical foundations of IP. It's given by the public to the creator of the artistic or technical work because of the contribution. And in the case of patents, it's kind of a reward by the public because the inventor contributes to the state of the art so that the public can benefit from it. And a single object, a seed, could be, for example, both patented and as a certificate as a form of plant breeders' rights. And intellectual property rights are transferable. Well, you can sell your patent, or you can license your patent, for example. It could be a non-exclusive license, so it means you have several licensees out of the same intellectual property right, or you can just exclusively give your rights to someone else. It could be a legal person or a natural person, meaning it could be a person that you communicate with or a company. And the scope of protection is usually national, but there is the unitary patent in the Europe. So I'll touch upon it in a minute. International treaties harmonize intellectual property laws in different countries and set minimum standards. But the harmonization is not absolute, and it's mainly about the procedural aspects of intellectual property rather than the substantial law. And I doubt it'll ever be completely harmonized in terms of substantive part of the law, because then you interact with national laws, and they have their unique hierarchies and unique rules, traditions, unwritten laws. So it's easy to harmonize the procedural aspects, but not the all aspects. So bear in mind. Yeah, what is a patent? Patent is a document. It tells the technical specification of the invention that you are seeking a protection for. So it looks like more or less the same throughout the world. So you have the name of the applicant, inventor, or joint applicants, and the listed prior art and abstract, and the main claims. So it looks pretty much the same. And it is an exclusive right for an invention, which means by using this protection granted by patent, you can just stop people using, selling, or offering to sell this invention within the designated territory that you indicate in your application. And this patent could be a product, a process, a product by process, or you can just include all depending on the invention. So there's no just one fit alls. And it's a new thing. It could be a new thing, a new way of doing something, or offering a new solution to a long-standing problem. And there's also so-called use patents, and they are for a specific unknown use of a known substance. And it should be for a therapeutical or surgical application that is unknown. For example, Viagra was originally a heart medication, but then it had other functions, so that specific function was patented later. As I said earlier, it's a negative right. A patent is a negative right. It's a monopoly of selling, using, making, offering to sell this specific invention that you describe in the patent application. And it is used to create a market barrier entry against your competitors. And that's why it is called a negative right. You just stop others and obtain a competitive advantage in order to recoup your investment, time, labor, depending on how you look at IP from a theoretical point of view. And the protection starts from the date of filing. This is really important because sometimes infringement takes place before the grant, between the filing and the grant. So the right holder, the patent holder, still could file for infringement cases, and the time is ticking from the date of application, the filing date. And for pharma inventions, there is a special extension, patent extension term, because they claim to lose a lot of time while obtaining accreditations or licenses from the authorities. So they could enjoy 5 years of extension. So it's like 25 years already. And after that 25 or 20 years, invention becomes, it's part of state of the art. So for example, the generic drugs, generic medications, they are expired patents. That's why they go really cheap after the patent expires, because there is no right. It's in the state of the art, so everybody can, it's in the public domain. You could think of it like that. So it's in the public domain. Anybody can make it, use it, sell it, or offer it. That's why pharma companies obtain trademark protection upon the main ingredient. So in case or when the patent expires, they could still market the same medicament under the same trademark name. So they could still generate profits even though the patent is expired. And of course, there's limitation to the rights, and but it varies. In the EU, it's the research exemption is statutory, so it's written in the law, but it's not clear in the US. It's not litigated enough in the lower court, so sometimes researchers could be hesitant to use patented things, technologies, while they're doing research R&D activities. But in most countries, patents will not directly interfere with R&D before commercialization. So it's an important point. It doesn't mean that while you're doing research, you find something and you started to commercialize, and the line is not always so clear. So bear in mind, it's just before, it's still the commercialization. And there are exclusions from patentability, and they are considered, some of them are considered non-inventions. For example, a discovery, a mathematical formula, an artistic creation, considered as non-inventions, so they cannot enjoy patent protection. And there are a group of subject matters that they are inventions, but they're excluded from patentability because of the morality and ordre public clauses. And it means there is a technical achievement obtained by the invention, but the lawmaker deliberately leaves that out of the patentability because it has moral consequences or bad consequences for the public, so it overweighs. And compulsory license is one of the limitations on patent right. Some of the technologies are so crucial that the courts could limit the patent holder's ability to impose whatever price she wants for the licensing. So at the beginning, I told that patents are monopolies, but they're not limitless ones. So the courts can interfere with the monopoly that is already given by the public. So compulsory license is one of them. It was highly debated while during the pandemic, but there was no compulsory license given even that, so under these circumstances. And there's a concept, a doctrine called FRAND, fair, reasonable, and non-discriminatory licensing. It means this happens with standard essential patents. For example, for 5G, in order to get into a market, if you're a producer of mobile phones, you have to have the core technology. So you're in hands of the patent holder of the 5G technology. So courts developed a doctrine called FRAND, and you can go to court and ask for a fair and reasonable and non-discriminatory licensing fee. And there are important W's for if someone is seeking for patents. What is the subject matter? It's really important here for synthetic biology inventions, because when these patent laws were crafted, we did not have that molecular degree of manipulation on the inventions. So when the patent laws were designed, it was usually for chemical components or mechanical inventions, which had a simpler, relatively simpler technologies and less risky consequences for the public. So that's why it's tricky for synthetic biology subject matters what to patent. Like, even if it has the eligibility requirements, it may not, as I just mentioned in previous slide, it could be deliberately left out of the patent protection scheme. And always good to consider where in terms of which country. And there are international agreements that you could file patent applications in an international filing mechanism called PCT, for example. It's provided by the World Intellectual Property Organization. And then you can enter national phases, but it's very costly, because then in each and every national phase, you have to pay for the translation fees and the National Patent Office fees. So it's quite costly. As of June 2023, EPO had unitary patent and unitary patent court. So the unitary patent is a single filing with an effect of EU member states. So it's a single patent. You don't have to enter into the national phases if they are the EU member states. So there is one examination, and you just have the patent, and you can just enforce in France, for example. And the Unified Patent Court has the ability to assess the validity and infringement of the European and unitary patent both. So Paris Convention is one of the international treaties. Actually, it's the most important one, because it sets the criteria and principles. It's the main founding international agreement. So it has a right of priority. If you file a patent application within a signatory of a Paris Convention, so you have 12 months to file in another Paris Convention signatory country. This is important because your invention will be assessed, its novelty will be assessed on the date of primary filing. So state of the art stops when you apply for a patent if it's a signatory of the Paris Convention. So it's called right of priority. And this could be really tricky. There could be several priorities for several claims. So it's, could be really complicated. There is a concept called grace period, but there is no grace period in the EU. In the US and in Australia, there is 12 months. If the invention is disclosed, you can still apply for a patent within 12 months in the US and in Australia. So the novelty will be assessed accordingly. When I say novelty, it's the newness of the invention against the state of the art. A patent examiner, when you file a patent application within a patent office, they look publications and relevant things for the invention within this subject. So they think if it's novel or not. And inventive step is looking for, it's also called non-obviousness. It is you can think it as if a useful technical function or a solution to a problem. If the invention has a solution to a problem or a good technical function, then it qualifies for the inventive step. Industrial applicability, it's relatively easy, and most of the inventions are industrial applicable. But yeah, the application has to fulfill. And in the US, there are two additional requirements called enablement and written description. And the invention should be sufficiently disclosed within a patent application. You cannot just arbitrarily write and think that it explains. So when the person who is skilled in the art has the application, which teaches the technical specification of the invention, he or she should be able to perform the invention by herself or himself. So it should enable the person who is skilled in the art to perform the same invention. And yeah. As I briefly mentioned, the invention has to be new, and new is like +1 than the state of the art. There should be one feature of the invention that is not included in the state of the art. And although there's no grace period in the EU, if there's misuse, if somebody used your invention without your knowledge or control, and you are the main inventor, then if you are able to prove that, you may obtain a patent. But in Australia and in the US, even if you disclose after 12 months, within 12 months from the disclosure, you could still apply for a patent, and that would not kill the novelty of the invention. But if it's on the 13th month after disclosure, your disclosure is acting against your invention as a novelty destroyer because it would not be considered as new. So the requirements won't be fulfilled for patent eligibility. Inventive step or non-obviousness is also assessed with comparison to the prior art. So if it's quite obvious to try the invention you describe in your patent application, then it wouldn't be considered as inventive, because any random person could do it who is skilled in the art. So it doesn't like, not worth, but there's not enough contribution since it was obvious. So it doesn't fulfill the inventive step. European Patent Office uses would test in order to assess non-obviousness, which is, even if a person who isn't skilled in the art could do the invention, would she or he do it? So if it's a no, if she wouldn't do it, then it's non-obvious. And a surprising function might be enough sometimes, for example, even if the method is trivial. So it is assessed case by case. Subject matter is relevant and challenging for synthetic biology inventions because it could be related to transgenic animals, which possibly has animal suffering, or devaluing life, or genetically modified plants that has a huge impact on the public, farmers, environment. It allows to control food supply, or genes, DNA. There could be morality and ethical and other public considerations. So that's why subject matter is quite challenging, could be quite challenging for synthetic biology applications. So I would like to talk about a case called Myriad that has been litigated in Australia, in the US firstly, and in Australia, which had a huge impact because it was related to patent protection for genes. And it had 3 kinds of genes in the patent application: gDNA, the isolated DNA, and the cDNA. So it wasn't just one subject matter and one product, rather it was 3 subject matters, and protection was sought for the method, for the product. So it was quite complicated. In 2013, Association for Molecular Pathology filed a case against Myriad Genetics because Myriad Genetics had patents on BRCA and BRCA2 genes as products. So the product claims on these genes were challenged, not the method claims. I mean, they were upheld. And these genes were, and the related mutations were linked to the increased risk of breast and ovarian cancers. So it was pretty important for women well-being and healthcare, and the costs of healthcare of the woman in the US for this case. So the Supreme Court of the US said mere isolation of the BRCA1/2 genes from surrounding genetic material does not pass the bar because it's already occurring in the nature. It's a product of nature. So that's why naturally occurring DNA, gDNA, cannot be patented. And I would like to draw your attention here, since it was a product claim, if the patent were not invalidated by the Supreme Court of the US, Myriad Company was going to be the only company to separate a person's BRCA1 and 2, a woman's BRCA1 and 2 genes, and produce the cDNA, although cDNA held not patentable because it's synthetically created, so it wasn't part of the product of nature. But as it was performing as it was the isolation of these genes. So they were the only one who were going to market the diagnostic tests. So it's quite limiting, and as a woman, I would say it's disturbing too. And US Supreme Court invalidated Myriad's product claims on these genes. So, but the synthetically produced DNA was allowed, so it's still patentable. And after the case, 4,300 patents, gene patents, were invalidated. So in line with this decision, US Patent and Trademark Office had to update the subject matter eligibility guidelines to guide the patent applicants who are seeking, who is going to seek like same kind of subject matter protection. And then America Invents Act had a clear article, section 33A, no patent may issue on claim directed to or encompassing a human organism, notwithstanding any other provision of law. So they had to include this within the law. In the EU, if the technical function of the DNA sequence is presented well enough, it's okay to obtain patents on genes. So there wasn't a dramatic change on the scope of the subject matter in the EU post-Myriad, but of course it affected like the way we look at it. So although there was no patentability questions held, there were still limitations on the scope of the patent applications that were challenged in opposition and appeal proceedings that took place at the European Patent Office. And we had the same case here in Australia, and the question was presented slightly differently here. So the High Court had to decide whether these gene patents that includes the subject matters, if they fell within the category of inventions. And then the US product of nature appeared differently in Australian context. So the Australian courts, they use the test of the artificially created state of affairs. And if it's there, so it might be okay. But the court had to decide whether the invention is materially different from the natural raw materials on which it is based. And this might change depending on how you look at the DNA. If the DNA viewed as a chemical substance, then one could say that it's materially different when it's isolated, but it's the genetic features of the DNA. It carries all the information. It's not just a chemical compound that with no extra function of carrying the genetic features of a human. So the court viewed the DNA as a genetically and capable of carrying the information. So the gDNA is held not patentable in Australia as well, whereas cDNA is still okay because it's synthetically produced. And so bear in mind always, like if you have an invention, what's the subject matter and when to disclose. Remember, if you disclose in the US or in Australia, you have 12 months to apply for a patent. In the EU, there's no grace period. So it might be better for you to apply for a patent and then disclose. And where? It's quite a costly procedure. So you may not have enough money or funding to file everywhere. So it's important to strategize where and when to apply. And I'm looking forward to your questions. I think we don't have questions. Let me check the chat. Okay, there is nothing on the chat as well. So please feel free to reach out. And if you have something in mind, I'm happy to help. Bye, everyone.